Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about lawyers, lawyering, ethics, and getting along. And not necessarily in that order. Let's go down to the beach and talk about that. See you there. So there are two trials pending right now that are of some interest to me. One of them is the Zachariah Anderson trial in Kenosha, Wisconsin, and the other is what they call the Ice Cream Man trial down in Tampa. But they're not interesting really for the issues involved because in the former it's basically a circumstantial case, and in the latter it's kind of a one and done sort of thing. The guy shot 6 people and did so on the basis of mistaken identity, if you believe the state's charges. Now, whether the jury believes that or not, we'll have to see. But what's interesting to me is the battle that seems to be going on between the prosecutor and the defense attorney in those cases. Let's take the Kenosha case first. In that instance, the Kenosha prosecutor was out interviewing a witness, and that's what prosecutors do. They interview witnesses. Nothing untoward about that. And during the course of that interview, he discovered that when she said she went to his house and he wasn't there, it turns out that she went to the wrong house. And so prosecution did what they were supposed to do. They turned that over to the defense, as they should under Brady versus Maryland, and they are still going to put her up as a witness at trial. So the claim by the defense was that by virtue of altering her memory, which I don't think he altered her memory, I think he corrected the record, but by virtue of having that interaction with her, he became a witness in the case. Well, we can deal with that in a little bit, but basically as a result of that, they sought to have him disqualified, and when they realized that wasn't going anywhere, they sought to have him removed from the courtroom during the period of time where that witness testified, because he is supposedly a witness in the case. Now, there is a rule that says if you are a witness in a case, a necessary witness in a case, you cannot advocate for one party or the other in that case. What does that mean? Well, the first thing it means is, let's suppose that the lawyer is standing on the street at a traffic light. The traffic light changes from red to green, and in spite of that, a car comes from the direction of the red light and plows into a car that had started to go from the green light. The lawyer is the only guy around. He's the only person who saw this accident other than the drivers of the cars. He is the only person who can testify as a witness to what he saw. He is a necessary witness. But let's also suppose that same accident, the lawyer is there, there's a priest, a legislator, a shopkeeper, and a mom with her 2 kids. And they all see this wreck. Does that mean that the lawyer is a necessary witness? No, because they can all testify. He doesn't have to testify. But does that mean he should represent one of the parties? Probably not. It is probably a prudential conflict, because if one of the other witnesses happened to let it slip that he was at the same place and he saw the wreck, it might be interpreted by jurors as him saying, well, I'm representing the guy who's in the right, when that may or may not be the case. So in that situation, you have a prudential but not a legal conflict. It's better for the lawyer to do what he should do and just not take the case. But in this situation, where it is the prosecutor and he is bound by the rules to turn over information to the defendant, and he's bound by case law to do that, when you have a situation like that where he discovers that a witness got information wrong and he turns it over, does that necessarily make him a witness in the case? No, because the witness that got it wrong can testify as to how she got it right. or how she didn't get it right, whichever the case may be. That is an important thing to remember, and it's important for a number of reasons. In this particular case, Judge Schroeder, giving the defense exactly what they wanted, allowed the prosecutor to be removed from the courtroom. Now, he could do it on the basis of the ethics rules, but he also has to do it on the basis of what lawyers call the rule. And the rule basically says nobody who is a witness in the case can hear the testimony of other witnesses in the case until they have testified. And if they are subject to recall at a later point in the case, they still can't hear it. They can only sit in the courtroom and listen to witness testimony if indeed they are an expert witness, and the testimony that they hear is necessary to their opinion. So, what does that tell us? Well, it tells us probably that the judge feels that there's probably a pretty strong circumstantial case in this case. And because he recognizes that an appeal is always going to be filed in a situation like this where somebody's on trial for murder, it's better to insulate the case from reversal by granting the defense motion than it is to let the prosecutor remain in there and it becomes an appellate issue later on. So he's probably trying to protect the record, and he's also probably trying to protect the prosecution, even though to this particular attorney, it certainly didn't seem like it. Now let's talk about the ice cream man case. In that situation, the prosecutor and the defense got into a series of squabbles about a witness refreshing their recollection. And there are rules about how you can refresh a witness's recollection. If a witness testifies, I was there and I saw that the light was red, you can't bring out their witness statement and say, well, would it help your memory to, read the statement that you made right after? Because doing that is not refreshing his recollection, it's impeaching him. So in those cases, it's not appropriate to call it refreshing recollection. In this particular case, however, the evidentiary issue there really doesn't matter because the lawyers got into it and started squabbling. So the judge said this.
I'm happy to send the jury home for the rest of the day, and we can go through all of them, including the administrative order, which adopts all of them in this circuit. I hope that that's not necessary, but if that is necessary, I'm happy to do it. What brings us to this situation is the argument that ensued about the refreshing of recollection, which is something that is essentially taught in the first year of law school, and debating over the semantics of it, and then sniping at each other and talking over each other, which is just going to end. It's not going to happen anymore, okay? Because if it continues, I'll simply declare a mistrial.
Anytime you have a judge saying that he is going to grant a mistrial because the two lawyers can't get along, somebody is going to get sanctioned. The other thing you have to remember is that the jurors see everything, and the jurors hear everything in a courtroom. And they pay attention to how the attorneys interact and how professional they are. And any attorney that treats the other attorney or any witness unprofessionally gets marked down in the jury's eyes. And that's not something that should be discounted. Now, in this particular case, I think the prosecutor apparently went to the Binger School of Prosecution because when he's talking to the judge, he comes off as, in my opinion, very arrogant. That doesn't mean he's wrong. It just means he is exuding this, calling it a stunt, that sort of thing. He is exuding a certain disrespect for the other side. Now, the jury didn't hear that. I suppose if they watched YouTube at night, they could probably learn that. But because they don't sequester the juries in Kenosha, we found that out in the Rittenhouse trial. But it's really interesting to me to see how these two sets of lawyers sort of get along. And I think it is always important for jurors to recognize that lawyers are human too. they can be just as upset and just as angry about being effectively being called a liar as anybody else would be. But I do think it's very important for lawyers to stay above the fray. At any rate, that's what I have for you today with regard to these particular trials. Hopefully you better understand the rules that are at issue there and why the judge granted these motions, even though it was somewhat out of character. I think you will find that many times in a case where the evidence is sort of overwhelming, that the defense gets a lot of breaks. That didn't happen in the Murdaugh case, but it did happen I think, in this Kenosha case. And again, that is in many cases the judge just trying to make sure that somebody who probably is guilty doesn't wind up winning a new trial on a technical issue that he could have prevented. If you have any questions, please leave them in the comments down below. Like, share, subscribe, and thank you to all 11,000 of you who have liked, shared, and subscribed. I am so happy that you did. Thank you for that. That is a vote of confidence that I sorely needed and very much appreciate. I hope you all have a great day. You have done something kind for me. I hope I have the opportunity today to do something kind for somebody else. And of course, if you have the opportunity, you should take it as well. Thank you so much for watching. Have a terrific day, and I'll catch you down at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.